नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
I'm not going to repeat the same kahani for executive power of the state. Okay, so where I'm talking about 73, you look at 162, so on and so forth. Okay, so you're going to look at. So I'm going to take that as given. Now we know that our constitution has a president, but we don't have a presidential form of government. I just want to spend a few minutes on this because currently this has been in the news in recent times. And I just want to sort of remind you about the discussion that took place in the Constituent Assembly debates. And one of the most important questions was the Union Constitution Committee, which was one of the committees set up in the Constituent Assembly, had to decide what form of government should we have. The predominant forms, two forms that were under debate, were the presidential form and the parliamentary form of government. Okay, that is the Westminster form of government, where there's an executive responsible to the parliament. Gandhiji, when he was outside, you know that he did not take part much in the Constituent Assembly debates at all. That entire period between 46 and 49, Gandhiji was there, but he completely kept away from this. One of the reasons was, of course, that under the Stafford Cripps and the Cabinet Mission Plan, the formula that had been accepted by the Congress party, that there would be a separate India and Pakistan, of course, broke his heart, and he didn't want to take part at all. So even if you look at his writings, he was speaking about other things, but he was really not addressing the draft constitution at all, which is quite surprising because here was a man who was so central to our freedom movement. Yet on the legal and political document that was to be drafted, there's hardly anything that he has said. I mean, if to the best of my knowledge, in a big concrete form, there's hardly anything that he said. And then after 46 midway onwards, he was not even in Delhi. He went away to Noakhali because the partition riots were ravaging the country in such a bad manner. The stray comment that he did make, and this is captured actually in Granville Austin's Indian Constitution, Cornerstone of the Nation. He made only one comment to the Congress party that let us have an indirect form. We will have village republics, which will elect from a panchayat system, and we will have the panchayat system as the basic building block of the form of government, and everything above that at the state level and central level would be indirectly elected. As it turns out, that panchayat idea was completely dropped. It took up till the 73rd and 74th constitutional amendment for class ka link mere paas nahi aata hai. I don't know. Can somebody just share with him, please? Yeah, just share with him the class link. I don't know. वो अंदर है तो क्या problem है? I don't know. Anyway, yeah, where was I? I was on Gandhiji. So, and I was on Panchayat Raj. So, 73rd and 74th amendment is when really, as a building block, but still not the basic block, it's only a devolution of powers. Panchayats don't have the power to make law. And if you don't have the power to make legislation, you are not a form of government at all. You have only administrative powers. That is why we use the word devolution. The actual key legislative powers or adjudicatory powers are not with you. At best, you have some form of administrative powers or executive powers of some sort. Now, when Dr. Ambedkar was addressing the issue of the Constitution, the Union Constitution Committee about the form of government, let me tell you right away that the well-known people in the Constituent Assembly, by that I mean Jawaharlal Nehru, Patel, Alladi Krishnaswamy Iyer, Patabi Sitaramaya, various people like this, Munshi, were all in favor of the parliamentary form of government. But there was still a group of people who believed that the presidential form of government was good. And so they put forward many arguments for the presidential form. And so finally, wrapping up the debate, yesterday I was reading, actually, I was preparing for today's class, I was reading the Constituent Assembly debates, and it struck me, and I thought I must share this with the class today. And what Dr. Ambedkar said was quite interesting. He said, there are two issues that we can highlight in the debate between presidential and parliamentary forms of government. And one is stability and one is responsibility. He said that in the presidential form of government, there's greater stability because there's only one man and there are no ministers that need to get vote of confidence or maintain the confidence of the Congress, because the president is directly elected. And while the president comes to the Congress for financial reasons, it's not as if every law, etc., that he pilots will have to be treated as a vote of confidence. In the parliamentary form of government, there is less, but each time which group will get to have the confidence of the House, but there is greater responsibility. And the way he put it was, in the trade-off between stability and responsibility, it would be good if we chose to go with the responsibility argument rather than the stability argument, and therefore his view was that we must actually go with the parliamentary form of government, and that's really sort of won the day, and the voting thereafter went with a parliamentary form of government. So rest, as they say, is history. That's the way it happened. But I thought the way in which Dr. Ambedkar had framed the debate was interesting, not as a presidential versus parliamentary form, but rather in terms of stability versus responsibility. That's the way in which he had framed the debate, and I thought that's quite interesting, and I wanted to share that. Now, we have a president. Article 52, there shall be a president. Article 53, executive power of the Union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. So the president doesn't operate alone. The entire bureaucracy, even the ministers in that sense, all operate and act in the name of the President of India. So the state operates in the name of the President of India. Then look at 53 subclause 2. Yeah, I'll take up the questions later. That the Supreme Commander of the Defence Forces shall be vested in the President. So in the final debate, the Union Constitution Committee, I was telling you about Dr. Ambedkar's address. He addresses this point. He says, we have gone beyond a pure parliamentary system because the head of the military, we have now given not to the Prime Minister but to the President. So that feature of the presidential form we have brought, and he highlights Article 53 subclause 2. Of course, the numbering is different. When the draft was being talked about, the numbers were different, but the essence is really this, that the defense powers now, military power, is with the President. So under 53 clause 1, executive power is vested in the president, and separately from that, under 53 clause 2, because look at the opening words, I want to make one point here. That is the way in which the Constitution examines executive power. It doesn't necessarily treat the defense power as implicit in the executive power. It gives it separately because it says without prejudice to the generality of the foregoing. It is part and parcel of the executive power, but it is made explicit that the president shall be the head of the defense forces, not the prime minister. There is one provision in our constitution which is extremely understudied. The only person I can see who has ever written about it was Professor P.K. Tripathi, and that is Article 34 of the Constitution, which tells us that you can have a form of military rule. So just for one moment, it's in the chapter on fundamental rights, very strangely. It's in the chapter of fundamental rights, but I think it's an oxymoron. It's a contradiction. Because it says you can restrict all your fundamental rights when martial law is enforced. And this is much deeper and much graver than emergency. When emergency is there, Article 21 and 22 cannot, 20 and 21 is not suspended, but Article 19 can be suspended. All other fundamental rights except 20 and 21 can be suspended. This is after the 44th. But when it comes to military rule, all your fundamental rights can be suspended. India, fortunately, I'm happy that I don't have to teach it because it means that we've never had an instance of military rule. But military rule has happened in India. If you remember the Jallianwala Bagh, after the passing of the Rowlatt Act and the great opposition to the undemocratic nature of the Rowlatt Act, martial law was imposed in Punjab. And martial law has, of course, been imposed at least several times in Pakistan. And the first Pakistan constitution, which got adopted after a great deal of effort in 1956, was suspended within 2 years of its adoption when General Ayub Khan came to the power. The Prime Minister was displaced and General Ayub Khan came, and one of his first acts was to impose military rule and then to suspend the fundamental rights. And then shortly thereafter, Ayub Khan gets overthrown with General Yahya Khan, and the 1962 constitution gets suspended in 1970 and during the reign of General Yahya Khan by Mr. Bhutto, Zulfikar Ali Bhutto. So there have been, and then again in 85, Ziaul Haq, there have been, excuse me, then Nawaz Sharif. To the best of my knowledge, at least 4 episodes of actually suspending the constitution and suspending rights. Now 34 says that notwithstanding anything in this part, and we're dealing with fundamental rights, so it's very profound, the complete override of fundamental rights can happen during martial law. Martial law, therefore, now when I come back to Article 53, Subclause 2. Without prejudice to the generality of the foregoing provisions, meaning, while the President definitely is vested with the executive powers, by way of abundant caution and by way of clarification, it is clarified that the supreme command of the defense forces of the Union shall be vested in the President and the exercise thereof shall be regulated by law. And the exercise of all these powers are, of course, you have the different laws, you have Army Act, Air Force Act, Navy Act. And because our entry 2 of our Schedule 7 of List 1 talks of armed forces of the Union, the paramilitary forces, and what is popularly known as the Central Police Forces, would also fall not within the armed forces of the Union, but would be covered by that particular entry in the 7th schedule. So, the armed forces, if you look, are not just the Army, Navy, and Air Force. Look at entry 1 and look at entry 2 of the Union list. This relates to that. When we say, and its exercise thereof shall be regulated by law, what is the entry under which you can make law with regard to these defense matters? The answer lies the entry 1 and entry 2. Entry 1 says defense of India and every part thereof, including the preparation for defense and all such acts as may be conducive in times of war to its prosecution and after its termination to effective demobilization. And number two, naval, military, and air forces. And then comes the very important, any other armed forces of the Union. And therefore, currently, for example, we know ITBP is there. Rashtriya Rifles is there, which administratively in a shorthand form are called the Central Police Forces. All these armed forces, these paramilitary forces, Central Police Forces, which are also armed, will all also be having laws. And when we say, therefore, that the President is the Supreme Commander of the Defense Forces of the Union, normally we are talking only of those three, but the others would also be stand included because of the way in which that. Now look at clause 53.3. Nothing in this article shall be deemed to transfer to the President any function conferred by any existing law. Now, existing law is a phrase that you will find frequently in our Constitution. Now, if you find a phrase like existing law, and you wanted to find out, is it defined in our Constitution anywhere? Then, as a student of constitutional law, your first port of call will be Article 366. I want you to look at Article 366 so that you're all familiar with the Constitution. Why I'm saying have the Constitution with you is that it's a document which you must be able to ruffle through and you must know all that it has. Look at Article 366. 366 is the definitional section. What would normally be Section 2 in a normal statute or enactment is Article 366, definitions. And if you look, so many words are defined here. And if you look at clause 10, it defines existing law. And look at existing law. It says existing law. Are you all looking at it? Do you know what I'm talking about? I missed it out in my chat box. Yeah. I'm looking at 366 and I'm looking at clause 10. Okay. Where am I? Yes, here I am. Existing law means any law, ordinance, order, bylaw. Now, as students, you're now all second year students, so I'm saying that you are fairly senior in the law faculty. The definition clause is in 366. We say existing law means. If our definition say means, then we say it is an exhaustive definition. It is not inclusive, it is exhaustive. This is something I'm sure you've studied already in first year. And you know the difference between an exhaustive definition and an inclusive definition? Anybody?
Yes, ma'am.
Yeah, who is
Ma'am, Mitansh.
Mitansh, yeah. Mitansh, go ahead.
Ma'am, exhaustive means that nothing will be included other than these things.
Good.
Ma'am, if the inclusive means, ma'am, it can be and something more can be added. It is not exhaustive. Like include word is used in definitions. It includes. Includes means not exhaustive.
That is, the definition is only illustrative. They've given you some examples, but it doesn't preclude you from including others. And we have statutory principles of interpretation to say what kind of things can be included or not. And we have rules like ejusdem generis, those that partake of the same genus, you know, genus as in biology. So if I'm saying animal means tiger, cat, then includes tiger and cat, then it means that basically I'll have that kind of a big mammal that I'll include. I will not be including COVID virus and all, okay? Because that would not be part of the ejusdem generis. So good. So this is exhaustive definition. Existing law means any law, ordinance, order, bylaw, rule, regulation. That is law made by the legislature. Denotes means what would be a good word to say it denotes? It indicates. Yeah. I think denotes means it indicates. Yeah. Good. Any law made by the legislature, ordinance, we already know when the parliament or one of the houses is not in session, the executive power to make laws in those times. Order, bylaw, rule, regulations would all be forms of delegated legislation, or subordinate legislation, which the executive makes under power given to it under a law to amplify or to clarify. So, for example, which is a law that you studied last year, let me just think. There are no rules in Contract Act. Are there rules in Hindu Marriage Act? There are no rules. So which is the law that you studied that had rules last year? Neither does transfer of property. Which are the other papers you studied in first year? I'm forgetting. CPC, yeah. Rules under CPC and CRPC. Okay. Passed or made before the commencement of the Constitution by any legislature, authority or persons having power. That is, what is existing law? A law which existed on the date of the Constitution. Now, this poses us an intellectual dilemma. You remember in my introductory classes, I talked about Article 395, which says that the Indian Independence Act stands repealed and the Government of India Act 1935 stands repealed. Article 395 repeals the Indian Independence Act of 1947 and it also repeals the Government of India Act of 1935. So many times a confusion arises that since the last article in the Constitution repealed it, is this not a destruction of our colonial past? Is there not a clean break made by the Constitution? If so, why should existing law continue to be valid and in force? And the answer is that while there is a break, though we say that the conjoint reading of the preamble with Article 395 explains that the Constitution was adopted by a body which was not authorized by British Parliament but which was sui generis put up by the people of India, and therefore there is an indigenous and an independent route to the formation of the Constitution. Yet, the definition of existing law under Article 366(10) tells us that this is a law which has some validity under our Constitution. And when you look at Article 13 of the Constitution, which we will come to, I'm not going to repeat the same kahani for executive power of the state. Okay, so where I'm talking about 73, you look at 162, so on and so forth. Okay, so you're going to look at. So I'm going to take that as given. Now we know that our constitution has.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।